So one of the things that I need to talk about to my clients who come to see me about deceased estates is whether probate is required. So you might ask what probate is. Basically, probate is a fancy word for proving a person's will as their last and valid will and having it endorsed by the court as a valid document. Probate is not required in all instances, but when it is required, it will give the executor the authority to administer a deceased person's estate in accordance with their will. One common misconception is that probate is required in all instances. This is not the case. So a lot of the time it will depend on the type of assets that a person holds and sometimes the value of those assets. For example, if a deceased person had real estate registered in their sole name, probate will be required, and this is because the New South Wales Land Registry Services will require the permission of the court to allow any transfer of title to take place. Another instance where you might require probate is if the deceased person had a large shareholding or a large bank account. So with financial institutions, they all have their own internal requirements and thresholds as to what they're comfortable with in order to release assets to an executor. These thresholds will vary between $20,000 to $50,000, but those institutions that are not comfortable with releasing funds without probate will require the executor to take that step and apply for a grant of probate. As I said, probate isn't required in all instances. For example, in relation to a bank account, if it does fall below the institution's threshold that it's comfortable with, then probate won't be required. So rather than needing to apply for probate, the executor would typically be required to complete some paperwork in accordance with the relevant financial institution's guidelines. Going back to the example of property, if the deceased person co-owned a property with someone, and that is as a joint tenant as opposed to a tenant in common, probate wouldn't be required because the law of survivorship applies. Similarly, with bank accounts which are joint, probate will not be required, again because of the law of survivorship. Another instance in which probate comes up is when we're dealing with the estate of a deceased person who was residing in an aged care facility. These accommodation refunds are often very sizable, and as you can imagine, the facility making the refund wants to ensure that it's releasing the funds to the appropriate person so that it doesn't put itself in a position where it will be sued. Most executors will say to me, how can we avoid probate? And there may be good reason to want to do that because it's quite expensive and there are delays usually involved in the administration of an estate when you need to go down the probate path. But there are advantages sometimes to obtaining probate. For example, it gives the executor that endorsement from the court that the will is valid. And there are certain statutory protections afforded to an executor who obtains probate and follows a particular process in administering the estate. One of the most significant protections afforded to an executor who obtains probate and advertises notice of distribution of the estate is the protection against claims by creditors. So each estate will be different and needs to be looked at on a case-by-case basis. Dealing with obtaining probate is a complicated process and we don't recommend that you try to do it yourself. So if you're an executor, we will work with you to determine whether probate's required, depending on the circumstances of the estate. So when I'm meeting with clients to prepare their will, we always have a discussion as to whether we think probate will be required. And there are actually some things that you can do, not in all instances, to avoid probate, which apart from anything else will save your estate thousands of dollars. A surprisingly common thing that I come across is that people die without a will, and that's an instance where you won't require probate. You're known as having died intestate. The process is different as there is no executor to apply for probate, so instead the appropriate person will apply for what's known as letters of administration of your estate. So if you're the executor or the administrator of someone's estate, please feel free to get in touch with one of the members of our estate planning and administration team.